Good afternoon, everyone. My name is Kathy Purdy. I am a marketing manager at Schoeneck King. I'd like to welcome you to this afternoon's COVID-19 webinar presentation. Just two quick housekeeping items before we get started. Please submit your questions through the Q&A box located at the bottom of your screen, and we will do our best to get to those throughout today's presentation. And if you would take a moment to complete the brief survey once the webinar has concluded, we would appreciate that. So to get things started, I'm going to hand it over to Pete Jones.
Thank you, Kathy, and good afternoon, everyone. Just thinking today, I think we are completing our 8th month of these weekly updates. It's been a long time. I think at the beginning we didn't anticipate that we'd be going this long. And one of the things I always did at the beginning was I tried to give a word or two of encouragement, because I think people were and still are doing very well. So let me just pause for a second and do that today. I think we're all doing very well with this. I know it's challenging, and we're here to help you try and navigate it. So we appreciate you being with us every week, and give yourself a little break and a little pat on the back, because this is these are certainly challenging issues. We thought we'd kick off today with the question that I'm sure is on everybody's mind, updates to the New York State Travel Advisory. Obviously, it's been challenging in recent weeks in terms of how we would implement the travel advisory with so many states on it. So the governor has come out with a new executive order, and there is new guidance on that. And we're going to have two presentations on it today to walk you through the nuts and bolts, and then also address some of the unanswered questions. So we're going to start off with Krista Cook. Krista's a member here in our Syracuse office, and she's going to give us the overview. Take it away, Krista.
Thanks, Pete. So as Pete suggested, I'm going to give everyone, try to give everyone a quick summary update of the new travel advisory guidelines in New York. As Pete suggested, it's been nothing but a lot of change and chaos in 2020. And with the upcoming holidays of Thanksgiving and Christmas and all the holiday seasons approaching us, many of us, including our governor, have been, a little bit concerned about how that impacts the current pandemic and the public health crisis and how to reduce that. Both the governor and de Blasio have tried to diplomatically suggest that people give some thought to their holiday plans and travel, and they're not the only ones. If you look at the next slide, we have at the same time thousands of college students who will be traveling throughout the country, coming back into their home states, coming into their communities. And that, as well as given a greater concern about keeping the level of testing up and the level of spread of COVID spread down. And certainly the more travel and the more people are coming in and out of states and into communities, that has created some anxiety. As a result, SUNY adopted a campus, a SUNY-wide policy that all of the SUNY students would need to be tested prior to departure of their SUNY campus, in an effort to make further efforts to reduce the potential for spread when these students come back to their hometowns. And part of that is what we've been hearing amongst both the federal and state government to some extent of testing, and recognizing that testing is certainly a powerful tool as a response to reducing the spread. So the next slide, Kathy. So we all know, most of you probably are well aware that the governor had issued Executive Order 205, and we've been living with that for a couple months since the end of June. And that required individuals entering New York State from certain designated states that had significant rates of transmission of COVID-19 to quarantine for a 14-day period. There were certain exemptions for first responders and essential workers, and the rules that are currently in effect, this Executive Order 205, it was clear that the quarantine must continue for 14 days, even if the individual had obtained a COVID-19 test and the test result was negative. So as Pete has suggested, there's been some challenges and hurdles with this approach, with a growing number of states that were on the high risk restricted states. And that list had to be updated. Our colleague here, Caitlin Anderson, has been telling you folks about this, that the number of states has grown tremendously. So it became difficult to manage. So effective November 4, there'll be new travel guidelines. The new travel advisory guidelines will allow out-of-state travelers to test out of the mandatory 14-day quarantine. If you go to the next slide, Kathy. So this new executive order, it is Executive Order 205.2. It applies to all out-of-state travel. So we will no longer have this list of restricted states or hot states. We now have a uniform rule, a uniform national rule. The advisory will apply to all states, regardless of their levels of COVID-19. So travelers, the only exception to this is that travelers from states that are contiguous with New York will continue to be exempt from the travel advisory. And that is in large part due to the practicality of the number of individuals who travel from contiguous states almost on a daily basis for work. So states such as Pennsylvania, New Jersey, Connecticut, those states will not be subject to these new travel advisory guidelines. So the new rule starts with a baseline. And the baseline is that anyone entering New York will have a 14-day quarantine, very much like we've been living with. However, it allows for, as I'd mentioned, a test out. Individuals traveling outside of New York must obtain a test within 72 hours of the departure from that other state prior to arriving back in New York. So before they come back to New York, they must get a COVID test. The individual must, upon arriving in New York, quarantine for 3 days, a minimum of 3 days. On day 4 of their quarantine in New York, the individual may obtain another COVID test. So they're going to get a second test in New York. If the test is positive, they're going to remain in quarantine. They're going to be subject to the isolation rules of New York's Department of Health. If both tests come back negative, the traveler can then exit the quarantine upon receipt of the second negative test. At that point, they would have received 2 negative tests, and that is how they test out of the 14-day quarantine. I would just mention that the individual, the second bullet where they have to quarantine for 3 days once they arrive in New York is measured from the time that they get to New York. So it's 3 days from the time they arrive in New York. So that's the basic rule on how individuals will test out. And the next slide. There are slightly different rules for individuals who travel outside of New York for a short period of time. If it's less than 24 hours, the individual does not need to obtain a test prior to the departure from the other state, and does not need to quarantine upon arrival in New York State. So the 3-day quarantine does not apply if it's a short visit outside of New York. However, they still have to fill out the traveler form that individuals have been subject to, and they must take a COVID test on the 4th day after their arrival. So on day 4 back in New York, they are expected to take a COVID test. Obviously, if it's positive, they would be subject to the New York rules about isolation. Next slide. The guidelines that have been issued are brief, but they instruct us that the local health departments will validate tests if that's necessary and issue isolation orders and contact tracing. The governor announced, or I guess reminded us, that for people coming to New York from out of the state, will need to have a negative test prior to getting on a plane. So if you're driving, that may not apply, but if you're flying out to a different state and for Thanksgiving and hope to fly back, you need to keep that in mind. Like the current travel advisory guidelines, the essential workers will continue to be exempt from these guidelines. And the guidelines still reference that this is really about a personal responsibility of all New Yorkers. And individuals who fail to comply with the guidelines are subject to a penalty of up to $10,000. Again, that is an individual, not an employer responsibility. But certainly New York employers want to be aware of these travel advisory guidelines. Next slide. So given the holidays and the number of employees who anticipate to go visit grandma, for example, out of state down in North Carolina or somewhere else, what is going to happen if the individual chooses not to get tested and inconsistently with the travel advisory? If an individual chooses not to get tested, they would be subject to the 14-day quarantine. The 14-day quarantine applies, again, as a baseline, so that would be applicable. I know that many employers are already contacting us to ask about, how do these new travel advisory guidelines impact my, ability to approve or deny vacation requests? And the answer certainly will depend upon your policies, your vacation policies. So you want to take a look at that, your CBAs. But as we mentioned in previous webinars, most employers have some discretion, and you'll want to give some thought to whether you can accommodate a period of vacation plus what will now be a mandatory quarantine. Now, certainly that mandatory quarantine will be maybe shorter, but that's circumstantial, and New York employers won't know necessarily if both of those tests are going to come back negative and allow the individual to come out of quarantine early. So that's something that employers are going to need to take into account. The last point I wanted to make too was, will the rule about pay change? Will the employee be entitled to COVID-19 paid sick leave during this quarantine, whether it's the 3 to 4 day quarantine or it's the entire 14-day quarantine? And we believe that rule will still apply, and that employees will not be entitled to the COVID paid sick leave if they voluntarily choose to travel and outside of New York. Any domestic travel, it subjects them to this quarantine. Obviously, that rule would not apply if the employer asks them to travel domestically. There is still some uncertainty around the federal rules about whether the FFCRA emergency paid sick leave would apply, but we are inclined at this time to think that it's possible, but we're waiting for more guidance potentially from the governor or a government about that application. Certainly, I think it would be even more unlikely than it was before that they'd be entitled to the FFCRA pay because they not only voluntarily engaged in the domestic travel, but if they chose not to try to opt out or test out, that would be unlikely, we think, that they'd be entitled to the full emergency paid sick leave.
Krista, thanks. We've got a lot of questions here, and frankly, there's no way we could answer them all. I think we've answered a lot of them, and I think Tom Eron, who's going to talk about some of the unanswered questions next, we'll touch on a number of them. But it's apparent to me that we need to do a pop-up webinar, and we will do that later this week, and try to walk through it again with some of the additional questions that are being answered here. But if you can't wait, or some of these situations are imminent, please contact us. Contact your favorite bond attorney, and we will get you an answer before then. So let's turn now to Tom Eron. There's a lot that Krista just answered, but there's a lot of things that we've been thinking about that haven't been answered, and Tom's going to take us through some of that.
Thanks, Pete. Good afternoon, everyone. Krista, thank you for that excellent summary. I think as we get started here, it's important to recognize that we have an executive order and we have a web page with information on it. It's very limited explanation as to this travel advisory. Krista has done a nice job of reading some tea leaves and giving us a perspective on it. We do have some time here before the holidays hit, and I would expect more detailed guidance from the Department of Health. And as we've said over a period of time, you need to pay attention to your particular county or local Department of Health because the interpretations are not always consistent across the state. But let me see if I can address some of the open questions that clients have already identified and that we've been thinking about since this announcement. And the first one is, and I use as my model the sort of the example of an individual who is traveling out of state, employee who's traveling out of state over the Thanksgiving holiday, right? So the first question is, that individual advises the employer that they have followed the protocol that Krista just laid out for us. They've taken the 2 tests, they've quarantined for 3 days, they received negative tests, and now they're ready to come back into the workplace. Can you, as the employer, require proof of those negative tests? And the answer to that, I'm very comfortable saying is yes. Similar to a circumstance where an individual has been out for a medical reason and you want to establish that they can return safely. There's no prohibition against asking for proof, in fact, that the individual has received the negative test. Some employers have looked to the question of, well, can we set our own standards here? There's a little bit of an inconsistency in the science. Why is someone who travels to Ohio subject to the travel advisory, but someone who travels to Pennsylvania is not? If we want to have a standard that is more strict, right? For example, a standard that any employee who travels out of state must get a negative COVID test before they're allowed to return to the workplace. Is that a permissible approach in New York? And again, the answer is yes. The state has set its thresholds. They are a combination of science and practicality. They are not necessarily where you would land as a decision maker trying to keep your workplace safe, and you have some discretion to be more stringent if you choose to do so. The third question that we've been pondering is, suppose you know the employee has gone out of state for a period of time, more than 24 hours. And so would be subject to the quarantine or the testing out procedure. But instead, after the Thanksgiving holiday, they show up at the workplace on Monday morning and say they're ready, willing, and able to work. On the facts that are presented here, you recognize that the individual is not in compliance with this new travel advisory. Krista mentioned that the travel advisory is an individual obligation, that the monetary liability rests with the individual, the obligation to comply rests with the individual. I have concern, and I think it's a concern that's been expressed by others in previous Tuesday webinars, that you can't rule out as an employer some element of this violation, which is what it would be, right? A violation of the travel advisory comes back on the employer in some way, shape, or form. It's not direct, but I would be concerned about allowing that individual into the workplace. One of the steps that the state has taken repeatedly in this effort to enforce its regulations is encouraging others to report a violation. And so it's very possible that if that individual were at work, there would be a report to the Department of Health that he or she doesn't belong there. And that just brings the attention of the Department of Health on your organization. To me, if that's the situation you're facing, a non-essential employee who's traveled out of state, reports to work, you're going to want to treat that person under your workplace safety plan like someone who's had a potential exposure. And a reasonable approach would be to require some measure of testing to confirm that they are not bringing contamination or risk into your workplace. I can understand many clients saying simply, you've got an obligation, employee, to meet the travel advisory, and we're not going to be complicit in your failure to do so. That's a judgment call by the employer, but certainly at some measure you're going to want to take to avoid an exposure in your workplace from the violation of the travel advisory by the employee. Kathy, if we could flip to the next slide, please. Does the test out procedure apply to limit the duration of the quarantine in other circumstances? All right, so this is this case, right? The employee goes out of state over the Thanksgiving holiday and either cannot or does not obtain a COVID test while they are out of state. Because the executive order specifically says the first test must be taken while the employee is out of state, that employee will not be able to complete the testing out procedure as it's outlined in the executive order. But logically, you would say, if the employee is back in New York and takes a COVID test, it is negative, remains quarantined for 3 days, takes a second test and it is negative, isn't that a sufficient compliance with the concepts that are in that executive order? I think that's a reasonable conclusion, but it's not yet supported by any guidance or directive from the government. It would not surprise me that the Department of Health came out with a clarification that this test out procedure could occur later in the quarantine process. I think the reason we don't see it now is because the government wants to emphasize that the first test is taken before the individual comes into New York. That's an important element of the contact tracing process to confirm whether or not the individual was infected while they were out of state versus while they were in state. A more procedural question that we've seen is in our daily screening to this point, we've asked employees, have you, in the last 14 days, traveled to any of the restricted states? Well, now all of the states are restricted. And so the question that I'm seeing is whether or not in the last 14 days, the individual has traveled internationally or to any state other than the 5 contiguous states: Vermont, Massachusetts, Connecticut, New Jersey, and Pennsylvania, for anyone who's geographically limited. And then, of course, if the answer to that is yes, there's a follow-up process. If it's international travel, right, that's subject to quarantine. There is no test out for international travel. There are, however, about 30 countries that the state has identified where no quarantine is required. And one individual asked whether St. Lucia is on that list, and the answer is yes. St. Lucia is not a country that you need to quarantine after you've traveled there. The other follow-up would be consistent with Krista's point. If it's travel outside the state for less than 24 hours, no quarantine, but a test on the 4th day. And if it's travel to another state for more than 24 hours, we go through the quarantine or test out process. Can an employer require a non-essential employee to comply with the testing procedure in lieu of the 14-day quarantine? This is probably one of the more difficult questions, right? Because there is some ability, it seems to me, to address this before the individual leaves. And particularly it goes to Krista's point about the discretion in approving time off. If you're approving vacation, do you have the discretion, do you exercise the discretion to say, we're approving your vacation with the understanding that when you return, you'll be subject to the limited quarantine, you will take the tests, and be available to return to work, hopefully on the 5th day that you're back. Beyond that, the question of an individual who is returning and chooses not to take the test, there is no clear path for an employer to require that individual to take that test, particularly if it turns out that they have protected leave that they can take after as part of the quarantine, because they will be subject to a quarantine order if they have not completed the test out procedure. And the last question I had on the slide is one I already answered. The test out option is not available for those who travel internationally. I'm going to wrap up there and just say there are a number of questions. We're looking for further guidance from the state. This is our best read at this point. And stay tuned because there will be more developments, particularly as we get closer to the holidays. With that, I'll turn it back over to Pete. Thank you.
Thanks, Tom. Yeah, a lot of information and you know, a lot of questions, folks. So like I said, we're going to do a pop-up. I think we've answered a lot of these questions, you know, in the course of the presentation here, but we will do a pop-up, and if you need an answer in the interim, please get a hold of us. Okay, we're going to move on. We're probably going to run over today, but it's a lot of good content. We want to get it to you. So one of the things that we had on the docket before we, you know, received the travel advisory revisions was to talk about, you know, kind of operating during this pandemic situation. And we have two sort of two presentations on that. First of all, Katie Schaefer is going to talk a little bit about, the disability related aspects, because they're tied pretty closely to the public health issue. And then Adam Mastroleo is just going to take us back through remember your plans, and are there some things that you need to update or be aware of. So let's start with Katie, and then we'll go to Adam.
Thanks so much, Pete. As Pete referenced, we thought we'd take this time to go over some frequently asked questions we've been getting regarding ADA and disability related issues. Things like, what kinds of questions can you ask employees? What medical documentation can you ask for? And reasonable accommodation issues. And these have been particularly vexing now that employers are trying to navigate bringing some or all workers back to the workplace while the pandemic continues and even spikes in several places. So let's jump right into some of these FAQs. So first, can an employer require COVID-19 test of employees? The answer is yes. This is less common, one of those screening methods that we've seen, unless you're in certain industries like nursing homes, for example, where it's mandated by DOH guidance. But some clients have considered giving these given the spiking numbers. This is certainly a mandated medical test, therefore it must be job related and consistent with business necessity. The current EEOC guidance says that applying that standard to the current pandemic, employers can choose to require COVID-19 testing for employees because an individual with the virus would pose a direct threat to the health of others. Employers in unionized settings are going to be cautious here. Instituting this condition is going to have to be probably negotiated over. There's certainly other concerns here, including logistical concerns, employee relations and morale concerns as well that you're going to take into consideration. So there's a lot to think about before implementing that type of screen. But the EEOC guidance says under disability related law, that is something you can require. Another thing I've been asked about, screening of teleworking employees. So we know that it's acceptable and it's even required in New York, screening questions for those working on site. The EEOC has cautioned, however, that for those employees who are teleworking, the employer generally would not be permitted to ask those types of screening questions about symptoms, positive tests. And really the analysis is these are medical questions because those with symptoms or a positive test pose a direct threat to the health and safety of others. But if the employee isn't setting foot in the workplace, that eliminates that concern. So talking about the daily screen for teleworking employees, best practice is to consider a different way of screening them out. Are you going to ask, are you working remotely that day? And if that's the case, you don't need to answer these questions about symptoms and positive tests and close contact. If you're going to do some kind of individualized screening as opposed to measures directed to all employees, so questions designed to determine if that person's had COVID, a temperature test, a COVID test that's beyond your baseline for all employees. You need to be able to show that there's a reasonable belief based on objective evidence that this person might have the virus. So that could be something like a display of symptoms, recent close contact with known or suspected COVID-19 positives, testing to determine the resolution of an infection. And really here, the emphasis is we're going to defer to the public health authorities on whether, when, and for whom that screening and testing is appropriate. So if you're following those recommendations, you're going to be okay. Another way I've seen this pop up during the screening questions is asking about family members who have symptoms or family members who have tested positive. And generally that's not the way you want to phrase that screening question because the Genetic Information Non-Discrimination Act, or GINA, prohibits employers from asking employees medical questions about family members. But it doesn't prohibit from asking if they've had contact with anyone diagnosed with COVID. So really the way that question was phrased, if you're asking about family members, is under-inclusive. You really should be asking about contact with anyone with symptoms or have tested positive. I want to focus now into kind of the reasonable accommodation aspect of this. And the emphasis, I think, here is that even during this pandemic, it's going to be an individualized assessment. You're going to have to go through the interactive process and an individualized assessment, both for your business, so your entity's income and resources, and ability to provide temporary assignments and hire temporary workers and remove marginal functions, as well as the individual's particular restrictions and needs. So what might be a reasonable accommodation in one situation for one employer may not be for another. What I've seen come up quite frequently is that employee is in a higher risk category due to some kind of pre-existing disability, but their job requires an in-person presence. So what do we do? Are there reasonable accommodations we can offer that person? And I think the answer, like so many in this area, is maybe. We have to go through that interactive process and not just assume because the job must be done in person that there are no reasonable accommodations. So some examples that might be a reasonable accommodation could be using plexiglass or other barriers, offering different or enhanced PPE, temporary job restructuring of marginal job duties, so taking away some of those marginal job duties as opposed to those essential functions, temporary transfers to a different position, a modified work schedule or shift assignment, or even unpaid leave. And again, it's going to be that individualized analysis based on the interactive process. I'm seeing a lot more of employees with some kind of pre-existing mental illness, and they're coming forward and saying that's been exacerbated by the stress of COVID-19 and asking for reasonable accommodations. So are they entitled to a reasonable accommodation? I think, again, the answer is maybe. The EEOC guidance discusses those with anxiety disorders, for example, or obsessive compulsive disorder or PTSD, as just a few examples, who might have more difficulty handling the stressors of the pandemic. And so with any accommodation request, there are steps that you as an employer can take to determine if a reasonable accommodation is required. And you can ask questions to determine whether the condition is a disability. You can discuss with the employee how the requested accommodation would assist him or her in enabling him to keep working. You can explore alternative accommodation that may effectively meet the needs. Remember that just because the requested accommodation is might be reasonable, if there are alternatives, you can offer an alternative as long as it's still a reasonable accommodation. So you can talk with the employee if there's some other way that you can meet their needs and offer that accommodation, you can do so. You can also request medical documentation if it's needed. So if the medical condition is not obvious or known, you can ask for medical documentation to determine if there is a disability. You can ask questions over medical documentation to determine whether the disability necessitates an accommodation. So some possible questions you might be asking, how the disability creates a limitation, how the requested accommodation will effectively address the limitation, whether another form of accommodation could effectively address the issue, and how the proposed accommodation will enable the employee to continue performing the essential functions of that position. If you grant an accommodation, does that mean, we're stuck with it, that it's got to be a permanent accommodation? I think the answer here is no. You can provide a temporary accommodation, especially during the pandemic. You can choose to place an end date on an accommodation. That might be a specific date. It might be when the employee returns to work. If there's certain, government restrictions are lifted. There are, in these micro clusters we have now, areas that are in lockdown, for example. So it could be when those restrictions are lifted. You could provide it on an interim basis or a trial basis if you're waiting for medical documentation, especially if the person's at a high risk. But note that if you do that, the employee can certainly request an extension of that accommodation. And that's something you're going to have to consider at that time. So just because we set a date of, okay, well, this is going to go through the end of the year, doesn't mean that once that deadline's up, you can discontinue the accommodation. You don't have to consider it again. But that is a strategy that you can use, especially if you know that the accommodation is tied to something specific related to the pandemic, that you can say, we're going to reassess this in a few months. We're going to reassess it at this specific date, or when our workforce comes back to the workplace. If you've allowed employees to work from home or to telework during the pandemic, are you going to be obligated to grant work from home requests as reasonable accommodations when you reopen or you recall workers to the work site? I think the answer to this is not necessarily. Employees still have to show that they have a disability-related limitation that requires working from home. If that limitation can be effectively addressed through another form or reasonable accommodation, then the employer can choose that alternative as opposed to telework. The EEOC guidance states that the extent you're now excusing the performance of essential function during the pandemic, the workplace reopens, you do not have to continue excusing those essential functions. A catch, of course, is demonstrating what is and not an essential function. But remember, you don't have to excuse an essential function as a reasonable accommodation. The guidance does go on to note, however, that temporary telework experience could be relevant to considering a renewed request. So in essence, you've been allowing it. It may be a bit more of a challenge to show why you can't continue to allow it in the future. It may be the person's not disabled, there might be another accommodation, or it might be that it's actually excusing an essential function that you don't have to do. So those are just a few of the frequently asked questions in the disability related arena. And with that, I'm gonna kick it back to Pete.
Thank you, Katie. Appreciate that. A lot of good information there. We thought it would be helpful to talk a little bit about maybe taking a look back. We call them reopening plans, but they're operating plans really at this point. And some of the things in there may have gotten a little dated or need a little attention. So Adam Mastroleo is going to walk us through some of his thinking on that.
Pete, thanks so much, and thank you everyone for joining us again today. I'm going to be quick here so that we can get out relatively close to on time. So one of the things that we're encouraging clients to do at this point is really take a hard look at your reopening plans. And like Pete said, I think a more appropriate name at this point is operating plans, to determine whether they are in compliance with current regulations. If you all recall, everybody in May and early June was scrambling to get these plans ready to go so that you could reopen. But now, 4 or 5 months later, we're sitting with plans in place, and there are a couple of things I think that you should highlight to go back, take a look at, and make sure you're doing properly. So first of all, by way of very brief review, these plans have a couple of different pieces to them. All plans do, regardless of your industry. Social distancing protocols, PPE protocols, cleaning and disinfection protocols, screening, and then infection response, or how you're going to respond to positive cases or exposures in your workplace. So I want to touch on each of those briefly and highlight one thing that I think you should look for. So with respect to social distancing, when these plans and the regulations first came out in May and June, many of them said words to the effect of, you can only have a certain percentage of maximum occupancy at your facility or your office space. So for example, offices, you can only have 50% of max occupancy. As the state put these plans out, people started putting them together and had questions about, well, what is maximum occupancy? So the state much later put out guidance in the FAQs, the reopening FAQs, about how you're supposed to calculate maximum occupancy. What I would say is this: go back, look at your plans, figure out what your max occupancy is supposed to be, and make sure you're calculating it properly in compliance with what the state put out at a much later date, the guidance on how you're supposed to calculate. So make sure that you're following the calculation of maximum occupancy appropriately. With respect to social distancing, the plans also discussed logging visitors. I know that we're seeing an increase in visitors at our own office, so I know that people are getting a little more comfortable now. Make sure you have protocols in place for visitors. What screening are you doing? How are you logging visitors? This becomes increasingly important as we're seeing more and more positive cases, because you're going to hear from the county health departments who are going to call you if there's a positive case and say, okay, who were the visitors or who would have had close contact with this individual? You need to have that information at your fingertips, know exactly where it is, know exactly how to access it. So make sure that information, you know where that information is and how it's being recorded. With respect to PPE, take inventory of your stock. If you had a certain amount of PPE available when you reopened, check to make sure that that stock hasn't diminished too much. Make sure you're replenishing face masks, replenishing cleaning supplies, replenishing any other PPE that you use to make sure you have everything and you're not going to have a shortage, particularly if we experience another spike and these products become hard to come by again. With respect to PPE, also another thing to make sure of, at least in the office setting, for example, individuals have to wear face coverings when they're walking around an office, hallways, common areas, etc. Make sure people are doing it. Make sure that you have a way to ensure compliance with your policies. If people are refusing or people are failing to comply with these policies, make sure you're going to them, to those individuals, have a process in place for correcting their behavior. The last thing that you want is evidence that employees of yours or visitors of yours are not complying with safety regulations. Somebody tests positive, and then you have a problem on your hands with respect to liability. I know I've talked on this webinar many times about defenses to claims related to COVID, and one of the best defenses is going to be you had a plan that complied with the guidelines, you implemented the plan, and you followed the plan. So make sure that individuals are following these PPE guidelines that you have put in place. With respect to screening, I would say Katie talked a little bit about this, Tom talked a little bit about this. Make sure you're asking the right questions. There are template questions that the state initially provided in May in these guidance documents that are out of date. So you're going to want to make sure that you are asking the correct questions about symptoms of COVID, exposure to COVID, positive tests, and travel. And we know with absolute certainty that your question on travel is going to have changed starting tomorrow. Lastly, I just want to cover quickly, if part of your reopening or operating plan is going to have an infection response, we called it a proactive infection plan when we first started these. This is the plan for how you're going to deal with somebody who tests positive or somebody's exposed to COVID in your workplace. Each of these plans is going to have some basic elements to it. Communication. Who are you communicating with internally? Who are you communicating with externally? You're also going to have a plan for cleaning and disinfection. If somebody's positive, what areas are you going to clean? How are you going to clean? Are you going to close down a portion or all of your office? Are you going to close down a portion or all of your facility? These things, make sure that you have clear protocols in place. I would encourage at this point all employers to run through tabletop exercises. Put out hypothetical scenarios, make sure you know every step that you're going to take and who is going to be responsible for taking the various steps. So Pete, I don't want to take too much more time. Those are some of the things that employers and businesses should go back, double check their plans at this point, make sure they're operating in compliance. And, I think that that's going to be very important as we go into this flu and cold season, to have those protocols and plans nailed down and in place.
Thank you. I think there's real insight in there. So a good idea to go back and make sure we're proactive. All right, so our last presentation for today, we're going to have Kate read, just kind of bring us up to date. We've been trying to update you on what's new with the schools, and because it is really, very well integrated or an essential part of operating, of how we deal with our employees, and frankly, what the burdens and situation is at home. So, Kate, please take it away.
Sure. Well, good afternoon, everybody. We have a couple of updates for you this week that relate to many of the other general updates that have been provided by other speakers on today's webinar. The big one is the travel update. So previously, I believe some of my colleagues in our school practice probably reported on the difficulty that schools were facing going into the holiday season, with the fact that the DOH had recently come out with guidance indicating that school employees are not essential workers. Essentially, no school employees could be deemed to be essential workers. That includes tax collectors through the school district. It includes those food service providers who have been directed by the governor, even at the height of the pandemic in the spring, to ensure that children received meals. School districts were essentially informed that they had no discretion to be able to deem any of their employees to be essential workers. So the recent revision and restructuring of the travel advisory has been welcome news to many of our school clients around the state, who will now have the option of bypassing the 14-day quarantine for those employees who decide to travel for the holidays. As Tom noted, we're fielding considerable questions about how do these guidelines now apply to things like international travel? What if the employee is traveling to a location out of state that does not have testing available and they wish to procure a test when they return to the state of New York. All those questions, we're obviously seeking additional guidance from the state with respect to how to navigate them. But as far as our schools are concerned, in terms of providing mandatory meal service and mandatory childcare services to their constituents, this is really welcome news. So one of our other updates that was of high priority for school districts recently is the issue around mask wearing. So in many other aspects of our life and many other sectors, mask wearing, of course, has become just a component of everyday life that nobody really questions. Schools have faced unique challenges with mask wearing. They have students who have experienced adverse childhood conditions or ACEs that have resulted in them having trauma reactions, for instance, when they wear masks. There have been children who are coming to school with the baggage of having had family members that have been sick with COVID or even perished with COVID, and are having a very, very stressful reaction emotionally and behaviorally to being forced to wear masks. There are additionally students who, due to their own underlying disability, have physical or mental or cognitive impairments that prevent them from being able to reliably wear masks. Finally, we have students that are just frankly oppositionally defiant and have behavior management issues who are coming to school and seeing being defiant with respect to mask wearing as an opportunity for flouting the rules and getting into trouble. So schools have been navigating how to enforce the DOH's mask mandate around all of these rather challenging circumstances that children present with in school. So we were relieved a couple of days ago to receive guidance from the New York State Education Department that clarifies the Education Department's expectations when it comes to wearing masks in school. So first and foremost, the guidance emphasized that students who are not able to wear a mask due to health or other mental health impairments cannot be excluded from school. So you as a parent may hear of this. If you're not a school employee, you may have your child coming home and saying, why is it that I have to wear a mask when little Johnny doesn't have to wear a mask in school? And it's important to be understanding that there are children that come to school with, as I said, physical, mental, cognitive impairments that actually make it dangerous or not advisory for them to be able to wear a mask. And they are specifically exempted from the mask guidelines from our state. And in fact, the state has emphasized that for students who are medically or psychologically or cognitively incapable of wearing a mask, that the alternative is to ensure social distancing. So this guidance has reinforced that point where a student cannot wear a mask, they must be socially distanced at all times. This would apply similarly to employees who are unable to wear a mask, although as Katie noted, there would be more of an ADA reasonable accommodation and interactive process that would have to be followed in that case to determine whether the requested accommodation is reasonable. So the department also emphasized that with respect to those children who profess to be medically incapable of wearing a mask, policies regarding mask wearing should be clearly explained to parents. And if it hasn't been done so already, districts really need to be putting written protocols in place for parents to offer medical reasons and medical documentation for why their children cannot wear masks. A general theme of the guidance is compassion and understanding the need to work with students to understand why, for instance, they're being oppositionally defiant and not being willing to wear a mask, and to err on the side of using discipline and other punitive measures only where it is strictly necessary. Our state education department has had a real sea change over the last 5 years of moving away from discipline and more towards restorative practices, more towards using positive behavior interventions for addressing maladaptive behavior in children. The state always takes advantage of a soapbox to be able to get that message across, and this guidance is no different. The state is emphasizing that where possible, where students are being oppositionally defiant, that should be treated as a learning experience, an educational moment to help explain to students the value of wearing masks for protection of others. The guidance is clear that where all methods have been exhausted and there's reason to believe that students pose a health risk, that a child may be transferred to remote learning in order to protect the public health. Now, what a risk to public health constitutes under that guidance is somewhat unclear. It's not clear whether that risk is merely the risk of COVID-19 transmission that exists in the community at large, or if there has to be a greater risk presented by the student. For instance, the student having maladaptive behaviors that result in a greater enhanced risk of COVID-19 spread, such as spitting, hitting, kicking, making physical contact with other students, etc. So where those health risks exist, the department is clear that a student may be put on remote instruction. Around the state, we're seeing that districts are having to be flexible about using hybrid methods of learning. So where they have seen COVID-19 outbreaks, they're under the obligation to then close down classrooms, in some cases entire school buildings, and opt into a fully remote method of engaging in instruction with children. So students who can't wear masks may be required at a certain point to transition to that form of learning. So apart from our mask updates, we also had an update from the governor regarding testing of students in school. Under the authority of Executive Order 202.68, the governor established the so-called cluster system, which requires that schools in red and so-called orange zones close for in-person instruction for at least 2 weeks. That executive order also mandated that schools in yellow zones were required to conduct random surveillance testing for a portion of their in-person population if they wish to remain open. In my experience representing schools around the state, those districts that have been in that yellow zone have actually elected largely to go to a fully remote model due to the administrative burdens and expense of having to test their population. I think we will be seeing more of that in the coming weeks, where you may see that if your school is now in a yellow zone, that district or school may be opting to roll out their fully remote method of instruction as opposed to having to integrate routine teaching. The governor finally then clarified last Friday that where a school is in a red zone, they may elect to actually continue to deliver in-person instruction, provided that they are testing all members of their community who are in person. Once again, this is a burden and an administrative hurdle that is very difficult for a lot of schools to surmount. So as a result, it's anticipated that we're going to see more activity of school districts opting to go remote as they are falling within these cluster zones. So that's about all that's going on in the school arena. Of course, it will be very interesting to see what happens as the holidays set in. Just like every sector, schools are obviously large employers in our community that are dealing with a myriad employment issues, as noted by Adam, Katie, and Tom and Krista as well, with respect to the travel of employees, with respect to reasonable accommodations and other routine employment matters as well. So that's about all I have for today, Pete.
Thank you, Kate. And thank you to everyone for being on with us today. We appreciate you joining us every week. As I mentioned, we're going to do a pop-up webinar at some point in the near future, next couple of days, on the travel advisory. And we'll be back here next Tuesday with another update. So thank you for being with us, and everybody, please stay safe. We'll talk to you next week.